Hey everyone, welcome to This Explainer. If you're the kind of person who really loves to figure out how systems actually work, well, you are in exactly the right place. Today, we're not talking about abstract legal theory or philosophical debates. We are talking about the ground beneath your feet and the absolute mountain of paperwork buried just beneath that. We're going to explore why real estate is, for sure, the absolute best testing ground for understanding how the law actually functions in the real world. Okay, let's dive into this. Most of us walk around with this super simple everyday assumption. Hey, I bought this house, my name is on the paperwork, therefore I own it free and clear. End of story. But is that actually true? Do you just own a physical structure, or do you live inside this highly complex web of legal relationships? That single, slightly unsettling question is the key that unlocks our entire investigation today. So, here's our roadmap for today. We're going to cover 1. Where law becomes visible. 2. More than physical objects. 3. Following the paper trail. 4. Myth versus legal method. And 5. What the record shows. Let's get to it. All right, part 1, where law becomes visible. People can argue about politics, contracts, or constitutional principles in these really broad, abstract terms all day long. But real estate actually forces us to confront hard physical proof. There's so much noise out there right now, especially from these social media gurus peddling magic legal loopholes. But property law, it operates through records. It takes all that abstract law and forces it into documents, signatures, and timelines. So when someone makes a bold claim, you don't just trust an internet rumor, you pull the deed. The public record gives us verifiable proof, not just some hidden or implied relationship. Moving right along to part 2, more than physical objects. To really wrap our heads around property law, we have to completely change how we look at a house or a piece of land. It is not just dirt and bricks, guys. A single piece of property can involve ownership, security interests, liens, easements, tax obligations, trust interests, and even constitutional protections. It's honestly staggering when you think about it. I mean, someone can live in a house without actually owning it. Someone can own property but still have a massive mortgage hanging over their head. A trust can hold property while beneficiaries have interests, and the tax authority, well, they can enforce claims over the whole shebang. So a single house is basically a giant puzzle of invisible, layered legal connections. Now, this brings us to a huge misconception. People are constantly confusing the terms deed and title. Listen, a deed is simply the instrument. It's literally just the piece of paper used to transfer an interest in land. Title, on the other hand, is the legal conclusion about ownership. A recorded deed absolutely does not automatically mean you have perfect title. No way. It could be forged, it might not have been properly delivered, or maybe it was signed by someone who didn't even have the authority to sell in the first place. The deed is just the starting point of your investigation, not the finish line. And here's another really vital distinction: the note versus the mortgage. The note is simply the promise to pay the debt. The mortgage, or the deed of trust, is the security instrument that actually ties that obligation to the real property itself. So the crucial point is, you must separate the debt from the collateral. If you're out there arguing about who owns the mortgage, but you're totally ignoring the promissory note or vice versa, you are completely missing half the legal picture. All right, let's jump into Section 3, following the paper trail. This is the part where we get to put on our detective hats and trace exactly how rights and claims attach to a property over time. And look, a foundational rule of this paper trail is that recording is just public notice. It is not magic. When a document is filed down at the county recorder's office, it just tells the world, hey, an interest is being claimed here. But listen, a fake lien doesn't magically become real just because a clerk put a stamp on it. These recording systems exist to establish a traceable chain and priority. They absolutely do not miraculously cure an invalid document. Speaking of claims, liens are basically the ultimate way the law makes itself visible. I mean, you've got property tax liens, federal tax liens, judgment liens, mechanics liens, and, the all too familiar, highly stressful HOA liens. Look, just because a homeowner has a deed doesn't mean nobody else has rights to that property. And priority absolutely matters here. For instance, a first mortgage might sit above a later judgment lien, while property taxes, they usually get special priority over private interests. Liens teach us that the real question isn't just who owns it. Actually, scratch that. It's more like who owns it and subject to what. Now, think about this for a second. What happens when the record owner dies, or maybe transfers the property to a trust? Let me tell you, property does not magically stop being governed by law just because someone passes away. In fact, it usually gets way more complicated. Did they have a will? Was probate opened? Who actually has the legal authority to sign a new deed? Sure, heirs might have an interest, but an interest is definitely not the same thing as legal authority. Fiduciaries, creditors, estate administrators, they all add these incredibly complex, invisible layers to that paper trail. Moving on to Section 4, Myth versus Legal Method. In the world of property law, there is this constant, ongoing battle between emotional, internet-fueled fake law and rigorous, methodical legal analysis. The myth-based mindset will tell you things like, the bank can't foreclose because money is fake, or I sent this magic document that totally discharged my debt. But the method-based mindset, it asks factual, procedural questions. Things like, was the notice of default actually sent? Was the assignment of the mortgage recorded? Were the notices even mailed to the correct address? And this brilliantly illustrates why asking precise, verifiable questions beats relying on internet pseudo-legal theories every single time. Here's another classic one. The myth says, oh, just put the house in a private trust so no one can ever touch it. Okay, well, a trust is not a magic force field against reality, mortgages, or the tax man. The legal method steps in and asks, wait, was the property actually deeded into the trust? Does the trustee even have authority? Are the property taxes current? Real estate forces legal clarity, guys. It totally dismantles the absurd and frankly dangerous idea that you can just declare yourself immune from the public record. And finally, Section 5, What the Record Shows. To cut through all this noise, we need the absolute best analytical tool out there. A timeline. Let's move to and see how this builds. Say in January 2012, a deed and deed of trust are recorded. Fast forward to September 2023, a notice of default is mailed. Then, January 2024, a foreclosure sale is held. By February 2024, an eviction action is filed. Boom. Building a timeline from public records immediately reveals the legal battlefield. It tells you exactly what happened, when it happened, what documents actually exist, and what deadlines have blown past. A timeline built on hard evidence is infinitely more valuable than an emotional argument. So how do you actually apply all this? Well, you build your own property record map. It's like a giant puzzle. Step 1, identify the property legally. Step 2, check the ownership record. Find the latest deed. Step 3, find those security instruments, like the mortgage or the deed of trust. Step 4, locate any liens or encumbrances attached to that property. And step 5, check the court records for any related litigation or probate files. This is exactly how you test claims and investigate the invisible layers of literally any property. Ultimately, real estate disciplines the conversation. It really doesn't care what you believe, it only cares what you can prove. So the next time someone makes a wild claim about property ownership, or you find yourself trying to untangle a super complex legal web, just stop guessing. Empower yourself to ask the single most important question in all of property law. What does the record actually show? Thanks so much for hanging out with me for this explainer. Now go out there and check your own paper trail.